Are you an applicant attorney or an injured worker dealing with a denied workers' compensation claim in California and you want to get timely medical treatment? There's a recent case come down called Gonzalez v. AC Transit that may be of assistance. Hi, I'm Michael Burgis. I'm a legal certified specialist in California workers' compensation and I'm a trial attorney. Gonzalez v. AC Transit is a recent case that's come down. It's a board panel decision, but it's dealing with when you have a denied case that is subsequently accepted, and let's say the injured worker was treating with another physician outside the MPN, maybe a lien doctor, but this doctor is outside the medical provider network. They've denied the case. Ultimately, the defendant picks up the case because there's a compensable panel qualified medical examiner or an agreed medical examiner. And now the insurance company is saying, hey, even though you've been treating with that doctor for a serious injury, we need you to treat in our medical provider network with our doctors. And I see this wrong 99.9% of the time. So first, before I go into the holding, let me go over a little bit of foundation. First, when a claim is denied, and an injured worker is treating with a doctor outside the insurance company's medical provider network, if the claim is subsequently picked up and authorized and the claim is then accepted, usually what you see is the defendant saying, I'm not paying for anything outside of my network, you have to treat in my network, do it now, and they fail to send all the required notices. What they're supposed to do is they're supposed to send what's called a transfer of care notice to the injured worker, their injured worker's attorney, and most importantly, to their treating doctor at that time. Now, Labor Code 4612.2, specifically D3B, indicates one of the most commonly used exceptions called serious chronic condition. But the insurance companies can't mandate or obligate an injured worker to go in their network, because first what they have to do is ask the doctor, is it okay to transfer into their network? Or is there a serious chronic condition that they're treating right now that transferring from you into our network would be detrimental to the injured worker's health and well-being? So what this case basically came down and said, and the holding of it is that applicant is entitled to continued treatment and care with the physician outside the medical provider network when a case was previously denied and where the injured worker's non-medical provider physician makes an objection under 4612.2 D3B and the serious chronic condition. So in this case, it looks like they were treating with a doctor outside the network who says this person needs surgery. They submitted what's called an RFA, or request for authorization for that surgery. I presume that went into the insurance company's utilization review and they said, the case isn't accepted, so we're gonna defer that. Later, sees a neutral panel qualified medical examiner. They then pick up the case and then they send the transfer of care and the doctor says, wait, no, this is a serious condition, I need to do surgery now. And then the defendant insurance company says, we're not doing anything, we're not paying, you have to treat in our network. And ultimately, bravo to the applicant attorney who litigated this case, because one, a defendant shouldn't be rewarded and rather should be penalized if they don't promptly accept a legitimate injury. And if somebody's treating outside the medical provider network, it's important to make sure that no detrimental harm to the injured worker is going to happen transferring into the medical provider network once they've accepted it. And, we got to back up our doctors, and more importantly, we got to make sure our injured workers' medical treatment is designed to help them and not harm them. And sometimes transferring away from a non-MPN physician can be absolutely detrimental. So again, this case, Gonzalez v. AC Transit, is nothing new, but it does reinforce Labor Code 4612.2 D3B in that when a case has been subsequently accepted, they have to send a transfer of care notice to that doctor, and that doctor should make an objection, and then for a reasonable amount of time, they're going to have medical control. In this case, that non-MPN doctor was awarded, and ultimately the defendant had to pay per fee schedule and had to pay that doctor for surgery even though he wasn't in the medical provider network. Now, this is very important for delays and transferring care that can cause harm, but also, look, if I'm an injured worker and I'm happy with my surgeon, I don't want to treat in the network with some BS surgeons that I don't know and I'm not comfortable with, right? So really, choosing the right surgeon is very, very important. And if you're an injured worker or an injured worker's attorney, and there's a non-medical provider network surgeon or physician that an injured worker likes and wants to perform surgery with, this is another tool to get it paid for under workers' compensation based on these fact patterns. Again, if you're an injured worker or an injured worker's attorney, if you have any questions or concerns, honestly, I'm here to help, and call us and I'll be more than willing to go over your case and the facts and see if this may be applicable and answer any questions.